Okay. Hello, everyone. This is Jackie from the Student Borrower Protection Center. Thank you for joining us. I know we switched this last minute, but I'm glad that we can make it happen. I am here with Persis Yu, who is our Managing Counsel and Deputy Executive Director from the Student Borrower Protection Center, Abby Shafroth, who is the Director of the Student Loan Borrower Assistance Project at National Consumer Law Center, Josh Rovenger, who is Senior Attorney in the Economic Justice Practice Group at the Legal Aid Society of Cleveland and also a fellow with the Student Borrower Protection Center, and Jeffrey Dubner, who is Deputy Legal Director at Democracy Forward. And they are going to share reactions from the oral arguments on student debt relief.
Thanks. This is Josh Rovenger. For me, the Solicitor General really crystallized the entire argument at the end of her rebuttal in the second case, where she highlighted that the stakes are really massive here for student loan borrowers. And the argument throughout both of the sessions emphasized that the pandemic had really devastating financial effects on low and middle income student loan borrowers, and that the risk of default upon returning to repayment without cancellation would be quite staggering. The Solicitor General and several of the justices throughout the argument really illustrated and hit home how the cancellation program was tailored to provide critical relief to these borrowers. And throughout, there was really no rebuttal from the other side on the impacts of cancellation.
Hi, this is Abby Shafroth from NCLC. So, well, much of today's argument focused on the threshold question of whether the court even has jurisdiction to entertain the parties' complaints about student debt cancellation at all. Solicitor General Prelogar also had an opportunity today to really hammer home the legality of the plan under the HEROES Act. As she patiently explained, the HEROES Act authorizes the Secretary of Education to waive or modify any statutory or regulatory provision that the Secretary deems necessary to ensure that borrowers are not left in a worse position financially with respect to their student loans because of a national emergency. That's exactly what happened here. Secretary Cardona determined, and the parties don't dispute and did not dispute today, that when payment resumes, lower income borrowers are likely to experience more difficulty and financial distress repaying their loans and have higher rates of delinquency and default than they did prior to the pandemic, i.e. that they would be worse off with regard to their student loans and their ability to repay unless the Secretary acts to ensure that they are not placed in a worse position. And so the Secretary used authority under the HEROES Act to deliver this relief, to provide cancellation tailored to preventing that distress and delinquencies from occurring. And as Justice Kagan pointed out, the justices of the court deal with congressional statutes every day that are very confusing. She said, this is not one of them. Congress couldn't have made this more clear in giving the Secretary the authority and the discretion to address national emergencies and protect borrowers in the face of national emergencies in this way. And that's what we've seen the Secretary do here.
This is Jeff Dubner with Democracy Forward. I'm going to address the major questions doctrine. Justice Kavanaugh said something that got right to the heart of the major questions issue. He noted that, and I believe this is a direct quote, this is right in the wheelhouse of what the Secretary of Education would be expected to do. Congress authorized the Secretary to waive or modify any provision of Title IV in a national emergency to prevent borrowers from being put in a worse position. And that's exactly what the Secretary did. So whatever you think about the scope of the major questions doctrine, this is authorized by Congress and satisfies whatever standard applies. But the Solicitor General put it correctly when she said, this is the whole point of the statute. The point is to give relief to student loan borrowers. So it's not the kind of unheralded and transformative action that the court has previously said could fall within the major questions doctrine. As Solicitor General Prelogar said, it's not just a plausible reading, it's the best reading.
Hello, everyone. This is Persis Yu from the Student Borrower Protection Center. I thought the justices expressed really an appropriate amount of skepticism of the standing of the various plaintiffs, calling in particular the nature of Missouri's harm as speculative and attenuated. Well, it's not even clear that Mohila even does suffer any kind of harm from the cancellation program. The state of Missouri most certainly cannot assert
Mohila's harm as its own. In the other case, I thought the Solicitor General did an excellent job of highlighting the mismatch between the harm that these borrowers are claiming that they suffered and the relief that they're seeking. I think this really goes to show the fact that this case is really at its core a politically motivated case and was not brought in good faith.
Okay, great. So those are the initial takeaways from all of our legal experts. Now we can attempt to do a question and answer. So reporters, you can raise your hand virtually and we will unmute you. Otherwise, you could feel free to put questions in the chat and then we'll read them aloud. So I'll give it a minute and see if there are any questions. Otherwise, we can call it. All right, well, it sounds like we have no questions. So we're gonna end this call, but if you have any follow-up questions, you can email us. Okay, I stand corrected. We have a question, which is, were you surprised by the skepticism Justice Barrett seemed to display about Nebraska's standing?
I think that it's right. I mean, I think that the skepticism that Justice Barrett displayed was very much in line with the case law on standing. And so I think, I certainly appreciated the questions that Justice Barrett raised with regards to standing, but I think, the case law on standing says that standing needs to be concrete and particularized, and it can't be speculative and attenuated. And so I think that that's in line with the existing case law, and I was pleased to see that Justice Barrett brought that out.
Any other responses?
I would just add that it sort of echoed skepticism raised by two conservative legal scholars who submitted an amicus brief to the Supreme Court, arguing that if the court found standing in the Six States case, then it would be really sort of breaking open Article 3 standing requirements and greatly expanding the reach of the court's power. And it would be really a dramatic turnabout. And I think that that Justice Barrett's questions reflected, appropriate skepticism and hesitation in doing that.
Okay, another question is, what do you think the biggest takeaways are for borrowers who are waiting to see if they will or will not get relief?
Yeah, I think obviously we're gonna have to all kind of stay tuned until June when we get the decision. I think borrowers, as we kind of look into the summer, will wanna just start thinking about repayment more generally. I do think that several of the justices, Justice Sotomayor, Justice Jackson, really underscored the impact that the pandemic had on borrowers and really, brought a full throttle defense and advocacy for these borrowers. I think Justice Sotomayor in particular, when she, focused in on the negative impacts of default that are going to be mitigated as a result of the cancellation policy, really spoke on behalf of millions of borrowers who face the risk of, housing insecurity or being unable to pay on other debts. So, while borrowers will have to wait until, we see the decision and kind of what comes next, I do think it's worth underscoring just some of the really important points that several of the justices made throughout the argument.
Okay, and we can just address a clarification about if standing isn't established, might the court strike down the forgiveness based on objections to merit, even if there isn't standing found?
So, in order to reach this is Persis, by the way. Sorry, I know we're going around and you can't see us. This is Persis, and in order to reach a judgment on the merits, the justices first have to establish that standing exists. It would be truly extraordinary for the justices to go to reach a decision on the merits without having standing, and would certainly contravene any legal precedents.
Yeah, sorry, this is Abby, I'll just add on. Standing is a threshold issue. It is sort of a gatekeeper of the Supreme Court and federal court's own power and authority to act. The courts cannot do anything to interfere with executive power or congressional power if they do not have authority under the Constitution to act. Standing is one of the things that is a requirement for them to have that authority. So they absolutely cannot reach the merits or do anything to strike down, or they could opine on the merits, but they can't resolve the case or strike down cancellation if in these cases, if the parties in these cases do not have standing. And I did want to highlight that Justice Jackson had some really interesting questions and remarks about this. There was a discussion of sort of the political significance of cancellation, and whether whether Congress would have wanted to give the Secretary of Education the power to do something of this level of political and economic significance. And Justice Jackson took that point and said that this is that very concern and the political significance of cancellation is reason that the court should be particularly wary and careful not to overstep its own authority and to uphold the constitutional limits on its power. That these are, these are questions that can and should be worked out through the political process unless there is a party before the court that has the power to invoke the court's authority. Otherwise, it is really overstepping the court's bounds for it to get at these political questions.
And this is Jeff Dubner from Democracy Forward. I think Justice Sotomayor had a quote that is also quite illuminating here. She said that asking them to rule in this case really has us, the Supreme Court, as the third branch of government, changing Congress's words because we don't like it. And that gets to the radicalism of some of the challenges to this program, both on standing and on the major questions doctrine, are really asking the court, in effect, to dispense with neutrally applicable rules and say, this is something that we think seems like a problem. And so we are going to use a loosey-goosey theory to avoid it. And that is a radical and dangerous road to go down.
Okay, we actually have a couple more questions. Would the court wait until June to say there's no standing? Is there further action if that's the finding?
This is Jeff Dubner again. The court could rule at any time in cases like this. It's often the case that they don't come out until the last minute, cases where you might think it's likely that different justices will come to different conclusions. So they could rule in June, they could rule sooner. If they ultimately hold that there's no standing, what we would expect to happen is they will vacate the injunction in the Texas case and the stay in the Eighth Circuit case and remand for further proceedings. This was just at the preliminary injunction stage, so there will potentially be further stages and further arguments, but at the sort of preliminary stage, that's what we would expect them to do if they find that there's no standing. They could also direct the courts below to dismiss the case altogether, but we'll see what they do.
And one thing I'll just add, just kind of zooming out a little bit, bigger picture, I think as has been said, there was a lot of skepticism about standing here. And I think when you just compare the lack of harm whatsoever on one side of the V and a whole bunch of harm to student loan borrowers as a result of the pandemic, and if this doesn't go through, it's just a really staggering comparison and one that I think came through in the argument.
On a similar note, do you think it was appropriate for the court to consider fairness? Does that even have relevance?
So I thought that,
This is Persis, you.
This is Persis, sorry, thank you. I thought that the answers to the fairness questions were really well done. And I think in particular, Justices Sotomayor and I think Kagan, really kind of rebutted that of like, when that's up to Congress to decide, and Congress decided that the Secretary has the authority to address the harms to student loan borrowers in national emergencies. And certainly Congress has taken actions in the national emergency, for example, with the PPP loans. So there is other relief that is available to other folks, but that's up to Congress. And what Congress did was they authorized the secretary to take this action specifically for student loan borrowers. And I thought the justices did a great job of addressing that. And I thought the Solicitor General, of course, did a great job as well of addressing that issue and showing why. I mean, certainly the question is fair to ask, but I thought that they addressed it appropriately and showed why this program is still fair for the borrowers, especially the borrowers who are in need because they're at higher risk of default and delinquency.
This is Abby. I agree with all of what Persis has just said. I also want to add that that part of what Justices Kagan and Sotomayor articulated is that Congress authorized and really required the Secretary of Education to focus on fairness between borrowers and the government. Like that is the question, sort of how can the government make sure that this government student aid program, a government benefit program meant to help people access education, isn't harming the supposed beneficiaries, particularly in times of emergency. And that's sort of the core fairness question that Congress authorized the Secretary of Education to undertake, and that's what the Secretary did. Now, Justice Roberts raised this question about, well, is it fair that some borrowers are getting student debt relief, but other people who might have small businesses aren't getting debt relief? I thought that was an interesting question, particularly in the context of these cases, because actually one of the two plaintiffs in these cases who is not eligible for student debt relief did receive a loan forgiveness through the Paycheck Protection Program for her own small business, which illustrates the point that that I believe Justice Kagan made, that there are a plethora of different government benefits programs. Sorry, it was Justice Sotomayor. There are a plethora of different government benefits programs, different relief programs. There have been $5 trillion of other sort of COVID pandemic related relief payments made out. And each relief program isn't going to help everyone equally. And that's expected. That is normal. That is how government relief programs must work. And so that's what we've seen here. And this relief program is essential to student borrowers and their families.
Okay, great. We are up on time. So unless anyone has any closing remarks.
So I'll just recap and say, I thought that this was
This is Persis, you.
Thank you, Jackie. This is Percy. I think this was a really great, I thought this was a really great showing and a good day for student loan borrowers. The Solicitor General did an excellent job of conveying to the court why student debt cancellation is both legal and necessary and authorized by the HEROES Act.
Okay, great. Thanks everyone for joining us. And you can follow up via email if you have any other questions or any other needs.